Hello, and welcome to the Hudson Institute's virtual panel discussion on artificial intelligence and intellectual property. My name is Devlin Hartline, and I'm legal fellow at Hudson's Forum for Intellectual Property. I'm thrilled to be here today to discuss the intersection of AI and IP with these three wonderful expert panelists. AI is a tool that is very good at performing tasks, such as processing data to find patterns, trends, and even solutions to difficult problems. It can be used in numerous applications like autonomous cars, drug development, finance, or cybersecurity. That said, AI can only do those things when trained to do so by humans. AI is great, but it lacks the ability to think creatively and have original thoughts like humans do, or at least that's my understanding. We'll see if the panelists agree. AI raises all sorts of novel issues when it comes to intellectual property. Can AI be the inventor of a patented innovation or the author of a copyrighted work? And what if we don't acknowledge the role of AI in creation and innovation? Stable and effective IP rights are critical to technological growth, creativity, and human flourishing. But are we doing the right things when it comes to AI and IP? Today, we'll explore how AI fits into the IP system and discuss whether changes should be made to ensure that the right incentives are there for creators and innovators who use AI. We'll also look at how AI can be employed in ways that respect the IP rights of others and how we can protect against AI reflecting our own biases and prejudices. With us today are three panelists who do work on different aspects of AI, and each one brings a unique perspective to the topic at hand. We have Dr. Ryan Abbott, who is a professor of law and health sciences at the University of Surrey School of Law and adjunct assistant professor of medicine at the David Geffen School of Medicine, University of California at Los Angeles. We have Paul Reinitz, who is director, advocacy and legal operations counsel at Getty Images. And finally, we have Hodan Omaar, who is policy analyst at the Center for Data Innovation at the Information Technology and Innovation Foundation. Thank you all for being here today. I'm excited to hear from each of you about what you're working on with AI. We're going to start with opening remarks from each of the panelists, and then we'll have a moderated Q&A to fill out the rest of the hour. And with that, I'll turn it over to Ryan Abbott.
Well, thank you, Devlin. It's very exciting to be speaking to everyone today. And I'm going to pull my slides up right here. And so you'd asked me to spend a couple minutes talking about artificial intelligence and what it is. And it is interesting that 60 plus years on from the term being invented, and with everything going on with AI right now, we still don't have a standardized definition of what AI is. And people still disagree on fundamentally what AI is and what it does. You know, this is an example of an AI. It is an AI that can autonomously diagnose and is FDA approved macular degeneration in patients. And so this is an AI with a medical, application. It does not act as a decision support aid to a physician. So it doesn't say to a doctor, here's some information, but you're the doctor, go make a decision. It actually diagnoses someone with a disease or condition. And in that sense, it is an artificial intelligence, but it is in a limited way practicing medicine and doing the thing that a doctor would do with a patient when the patient comes in with macular degeneration. And I think it's a useful way of thinking about AI. It is a tool in the sense that it is made by people and it only does what it's told to do. But the core premise of AI is that it's a functional definition. It is a machine that behaves in a way that if you saw a person doing that, you would attribute cognitive abilities to them. And so it can be, as you've said, a car that drives itself or a passenger from point A to point B, but does so in a way that it is automating the thing that a cab driver or an Uber driver would do to get there. And so I think the right way to think of AI is in a very functional sense. Some people do think about AI in terms of how it's designed. There's a lot of ways to make AI, from neural networks to conventional rule-based architectures. Recently neural networks have led to some great breakthroughs in AI functionality, which isn't so much new design, but is a lot of improved hardware and data to train AI. So there's a lot of ways to design it. But it is challenging as we're thinking about regulating AI and what sort of legal rules best apply to AI. It's important that we all be talking about the same sort of thing. And so I think it's useful when you say that an AI can't do something creative. I would very strongly disagree with that and say you can go right now to any number of commercial websites, from Deep Dream being operated by Google to Wombo Art to Brandmark.io to the OpenAI Jukebox, and see that you can have AIs that are functioning in a cloud. You can give it some very basic parameters, and it will make you something that is creative and original. And the AI doesn't understand what it's doing in the way that a person does, but functionally, what it's doing is the same thing that an author or an inventor may be doing. This hasn't escaped the attention of policymakers. The commercial and social impact of this is going to be tremendous. And countries and jurisdictions around the world are setting up policies and regulations for AI because they want to be at the forefront of AI development. The U.S. National Security Commission even published an influential report last year suggesting that AI and IP is a critical component of national security, along with some of these issues. And, in general, that we're losing the AI arms race with China, and that we should start investing $30 billion a year in AI research, which is what we invest in life sciences research. But to show you that AI and IP isn't just something for patent and copyright geeks to nerd out on, although it is definitely that. It's something that's going to have a lot of commercial and social impact as AI challenges a lot of the ways we function in IP. And this isn't just policies, it's detailed regulations coming out of bodies like the European Commission. This one not so focused on AI and IP, but others that are. The U.S. Copyright Office and Patent Office have recently done consultations on this. The UK Intellectual Property Office is on its second consultation, recommending perhaps changes to the law for Parliament to make for what AI generated works for copyright and patent. And there's all sorts of exciting and great opportunities and new challenges presented by some of the things being done by AI. For example, Clearview has trained an AI to do facial recognition for law enforcement technology. Facial recognition technology for law enforcement agencies using 10 billion images it found on the internet. That's something we've just not had to deal with in the past, or, to this level with, is that sort of use permissible? And I know Paul's going to talk about that in particular. And new sorts of applications of AI making things like deep fakes. It's not the first time we've had deceptive technologies, but the scale and ability to engage in it and the convincingness is new. If we go to an example that's nearer and dearer to my heart, AI is making new content and doing the sort of thing that a human author would do. And the bar to making a new piece of copywritten work is very, very low. Me pressing a button on my iPhone and taking a picture. AI has been doing this a long time, since the 60s, but if you go back and listen to that music, it's awful. What's new about it is that the music is getting to be kind of okay. And if you go to the OpenAI Jukebox initiative, you can hear an AI that's made music that Frank Sinatra or Elvis Presley might have made, except not nearly as good, but kind of passable if you're not listening to it that well. And in 5 or 10 years, AI is probably going to be making music that's playing on the radio because it's that good, and making an unlimited amount of it because it will cost almost nothing to have AI make that work, and making it in new ways where it makes music specifically for you to go along with your emotions or to go along with an activity that you're engaging in. And that sort of behavior is going to be profoundly disruptive legally, culturally, and financially. You know, I'm a patent attorney, and this is a case Siemens presented in 2019 at the WIPO First Conversation on AI and IP. The green thing is a car suspension. The silver thing is a car suspension designed by an AI. And the Siemens wanted to file a patent on this, but couldn't because all of the engineers involved in the process had said that they didn't invent it. They said they had an AI that optimized industrial components. They gave it publicly available information. They told it what they wanted in a car suspension, which was well known. And the output it modeled and found it outperformed on the performance indicators they were looking for, but that was obvious to anyone who would have looked at it. And so the engineers basically said, we just told it what we want and gave it data, and none of us were an inventor. And Siemens thought in response to that, well, I can't get a patent. And they say this is not an isolated incident. Now, it's a lot harder to make an invention than it is to make something that gets copyright protection. But AI is very quickly being adopted by mainstream life sciences companies for drug development and repurposing, and in materials engineering, and also in AI development. AIs are making more AIs or training AIs or adjusting AI architectures. So AI is really doing a lot these days. And there's a real question about, well, is this sort of activity something that we want to protect with the IP system? And so I'm leading a group of patent attorneys and filing a test case for 2 inventions made by an AI. And the argument is that the AI can legally be a patent inventor because it did, in fact, invent these things, but it doesn't have legal rights or personality, so it can't own property. The person who owns the AI owns these patents the same way that if I own a 3D printer that makes a beverage container, I own that beverage container. If I have it make a 3D design for a beverage container, I would own that as a trade secret. And if I file for a patent on it, I should own that patent. And having that framework in place will encourage people to make, build, and use machines that will generate inventive output, that will get them to disclose inventive output, which benefits public knowledge, and will encourage companies to commercialize developments that come out of an AI. We received last summer our first 2 patents in South Africa. These were substantively examined in the UK and in Europe and found to be patentable. South Africa only examines for formalities, but where there have been rejections, it has been on that basis. In the United States, these applications were denied on the grounds that the Patent Act says a person is an inventor and therefore you can't have a machine invent something. We're currently challenging that in the federal circuit, so we'll see what happens. And that case is ongoing now in a number of jurisdictions. Fresh off the press on Valentine's Day, we also took a piece of AI generated artwork and attempted to register a copyright on that, again, with the claim that this is something made by a machine where there is no human who is traditionally qualifying as an author, and that the person who owns the machine should own the copyright in this. And the Copyright Office has disagreed with that, but the Copyright Office is relying on dicta from cases from the Gilded Age in support of that policy and the idea that only a human mind can be creative. And it may be that only a human mind can truly appreciate and have semantic understanding of what it's doing, but machines can certainly engage in functionally creative activity as well as, or sometimes better than people. And if copyright law exists in part to help us generate new valuable, socially valuable works, then that's something you want to encourage, whether people are doing it directly or AI is involved in this. As a final point, this is an argument that I make in a book that just came out, The Reasonable Robot, or recently came out. You often have, as AI is advancing, AI and people doing similar sorts of things, but the law treats those activities very differently. And we may all be better off as a society if the law did less to discriminate between AI or human behavior, whether that's AI or people driving cars, making new creative works, or even, essentially engaging in taxable activities. The book recently came out in Chinese, although I was disappointed to see it was translated to Rational Robots, The Future of Rule of Law by Ryan Abbott. But then I noticed that actually the human translator did appropriately translate it into Chinese. My browser's AI was mistranslating it back into English. So automated translation technologies are amazing. They aren't quite at the level of people yet, but we'll get there. And I'll end my comments there. Thank you.
All right, thanks, Ryan. Before we turn over to Paul, I just have to ask you, so these rejections in the United States, are they based on the text of the Patent Act and the Copyright Act, or are they going like to the Constitution and saying inventor and author under the Constitution means a human?
Well, the constitutional arguments have been raised by us at the Federal Circuit. The Patent Office its argument has essentially narrowed down to the Patent Act uses terms that through their plain language refer only to natural persons, and therefore you cannot have a machine invent something. Our position is that that language can only be understood in context, and the Patent Act is designed to have purpose of interpretation, and a machine has factually acted as an inventor, and prohibiting protection for that sort of thing would run afoul of everything the Patent Act is intending to accomplish.
Fascinating. Wow, that's really cool. All right, I'll turn it over to Paul now.
Great, thanks. Let me just share my screen. Okay, I assume you can see this. Let me just move that out of the way. All right, great. So before I start, thank you, Devlin, for inviting me to speak on this panel, and for the Hudson Institute for having me. It's really an honor to be here, especially with such esteemed co-panelists. I really enjoyed Dr. Abbott's presentation there. I think you brought up a lot of really interesting topics, and I'm looking forward to the discussion that we're going to have afterwards. And I do think that what you said really set me up well for what I want to talk about today, and it's more specifically about AI and the content licensing industry, and sort of the issues that we're facing. So when we talk about AI in the content licensing industry, we're often talking about computer vision and visual machine learning. Now, one of the basic concepts of machine learning is that machines are learning from training data rather than from explicit programming. And in computer vision contexts, or in those applications, machine learning training is often data that is images or videos or other data that's derived from that. And it could be labeled or not, often could be copyrighted content. Now, innovation in this area is booming, and it's really impacting a wide spectrum of sectors already. And that innovation is being spurred on by both industry and academia, which are really advancing the state of the art quickly. Now, when we're talking about AI visual and visual machine learning, really training data is a key concept that we need to understand. And that training data could be sourced from a variety of places. It could be available, publicly available data sets, or it could be proprietary data, like a company's proprietary user data. And then finally, I think it's also really important to think about the models that are being created, not just the data. So those AI and machine learning models, those could be custom built. They could also be available on the market pre-trained. They could be open source or proprietary again, and they could be accessible via API. And you need to think when thinking about how these models are being used and what intellectual property is being used in them as training data, you kind of need to think about the whole picture. So hopefully that is a decent background. And I think that, as Dr. Abbott brought up, this brings up a lot of novel legal and policy considerations. And it's really forcing us to think or rethink the interaction between computers and the creative process. Obviously, Dr. Abbott's put a lot of thought into this already. As he talked about, what is the legal standing of computer generated or synthetic work? Is copyright going to be available for AI generated work? We know some people would like to see that. Some people would not. Should AI simply be viewed as a new tool that can be used for human creation? Photography was once a new tool, or cameras were, and now photos are seen to be eligible for copyright protection. And if we do see it as a new tool, what is that requisite level of human creativity needed? Is it what Dr. Abbott's putting into his work that's being declined by the Copyright Office, or is it some higher level? I think we don't know yet. Another really important question that we need to think about is, what is the role of underlying data and how do we treat it? What if that underlying data is copyrighted work? Should we be treating it differently? Do we need to respect copyright? I would say yes. Now, when we're evaluating it, should we be looking not only at that work, but thinking about what's the output of the AI applications that are using that data? For example, AI systems that are trained to generate synthetic content, often through the use of GANs, or generative adversarial networks, they rely on high volumes of image data for training, testing, and validation. Often that could be copyrighted data. And if the output of such systems competes directly with the market for that underlying data, should licensing be required? I would think so, yes. Now, another issue that comes up often is third-party rights. Copyright is one that I just noted, and I think it is an important third-party right that needs to be considered. When creative content is used in that commercial context, it seems really only fair to compensate copyright owners for that use. And really failing to do so threatens to devalue human created work. Now, beyond copyright, privacy, I know we're talking about IP here, but I think this needs to be addressed. It is a huge concern, and specifically the use of biometric data. When visual content contains images of people, there's a risk that their biometric data could be used without their consent. And this is not just some theoretical risk. This has led to multi-million-dollar litigation and settlements, primarily under the Illinois Biometric Privacy Law, or BIPA, and it has involved some of the biggest names in the industry. And this is not something that's going away. I mean, you may have seen in the news last week that Texas is suing Meta, the owner of Facebook, for using biometric data collected from images uploaded by their users, presumably or allegedly without consent. Now, another big consideration or policy consideration is regulation. And I think in the context of images, should regulation of synthetically generated content exist? Now, while many AI innovators are committed to ethical development, there have fears and concerns that have led governments worldwide to consider regulation. In the context of visual data, synthetic content has been in the crosshairs globally, especially when you talk about deep fakes or disinformation. In Getty Images Global Advocacy, we've really stressed the danger of over-regulation in this area, and we've been trying to talk about having a distinction between when synthetic content used in the editorial context or in the creative context. And just to go a little bit more into that, so in the editorial context, deep fakes, that can be used to spread disinformation. And I think few would argue against that being incredibly damaging to society in general. We agree with that position, and we think it's important to invest in tools and to promote policies that help end users understand the provenance of such content, and if AI has been used to generate or modify it. Along those lines, Getty Images is a member of an organization called the Content Authenticity Initiative, or CAI, and we believe that the standards published by the Associated Cross Industry Group, C2PA, that really presents an excellent solution. Now, in the context of creative work, we think that using those standards for provenance it should also be seen as good practice. However, there are really amazing opportunities for creative expression. Really, they could be endless, and we think that direct regulations, could be damaging there, and we need to treat those two types differently to promote that creative use. Now, how can we actually promote this sort of innovation? And we call responsible innovation as well as data licensing. Like I just said, I think that the opportunity for licensing data for computer vision and machine learning projects is really exciting and promising. And in this world of evolving world, we want to see trustworthy data. We think that if you use trustworthy data, where your data came from, it's going to lead to more trustworthy AI products. And on the flip side of that, if there really is disrespect for third-party rights, not only are you going to have bad AI products, but you can have irreparable damage to those third-party rights holders, both privacy and intellectual property. And so, along those lines, we think that promoting ethical and transparent behavior can give AI developers the legal certainty they need to really create an effective industry and commercialize these things without having to worry about lawsuits from third party for copyright, for privacy, etc. And also let people know that there really are developing and efficient markets for licensing data. I disagree with one thing that Professor Abbott said before, in that in creating synthetic data synthetic content down the road, he said, and I agree that doing these things at scale is very possible, but it's not necessarily free, right? And so if we are going to be creating new content, especially if it's trained on existing content, that existing content should be licensed. Now, finally, I think one really good policy thing to think about here is transparency. And if maybe requirements are a little too strong, but I think best practices is the way that we like to think about it. And so transparency, we think, is going to encourage respect for third-party rights. If people know their data, are confident with their data, can share what their models were trained on with customers, there's going to be more respect for third-party rights. And I think that, as I expressed before, is only a good thing. We can also see that transparency can help us understand or view into that black box of models and potentially help reduce bias in those models. Now, one thing that we've been advocating for at Getting Images is this concept of auditable records that detail what training, testing, and validation data was used in AI development. And this doesn't have to be public records. This could be something along the lines of how accounting records are kept today internally, where they may be discoverable in the context of litigation, and otherwise they can be private. And with these sorts of transparency, best practices, at least from our content, and when we license it, we can really make sure that those human creators get compensated when their work is licensed and used in the AI and ML context. So that is all I have for now. I'm looking forward to the discussion.
All right. Thanks so much, Paul. And it makes me wonder, Ryan talked about an AI looked at 10 billion images to do facial recognition. And I'm thinking well, that probably wasn't licensed. Is that 10 billion infringement? What are the statutory damages?
Yeah, well, and I think
many questions about that.
Yeah, Clearview AI, at least in my view, and I think probably Dr. Abbott recognizes as well. I mean, they're incredibly controversial, right? They, they're being sued on multiple levels. And their position is they can just go out and crawl the web. And if something's on the web, it is public. That is exactly what I'm talking about when having disrespect for third-party rights that exist. There are privacy rights there. There are IP rights there. Clearview AI is the poster boy for what you should not be doing.
All right. Okay, so let's start it over, and Hodan, I can't wait to hear what you have to add.
Thank you so much. Let me just share my screen. Can you see that? Great. So Devlin and to the Hudson Institute, thank you so much for having me, and to Ryan and Paul, great presentations. I really enjoyed that. I'm looking forward to the discussion. So as Devlin said, my name is Hodan Omaar. I'm a policy analyst at the Center for Data Innovation, and I really focus on AI policy is one of my main focuses. And so I wanted to look at this from a US policymaker's perspective, and in my kind of short time, consider some of the issues that are kind of most relevant to them as they seek to kind of bolster the AI ecosystem. And there were three main considerations I thought worth noting, and they essentially cover the who, what, and where. So first, who should receive IP protections, which is the motivating question behind the debate on AI inventorship. Ryan already covered this, so I won't spend time on that. Where I want to really spend some time is what should receive IP protections. And this is, talking specifically about patent eligibility and the challenges that AI presents for existing doctrines. And finally, a quick note on where one should get IP protections. I want to spend a quick minute on the need for broadly similar approaches to AI and IP among the United States and like-minded nations. So jumping into patent eligibility, which I will say I actually saw on Ryan's slides about the National Security Commission was one of their first kind of issues. So the motivating question for policymakers here is, can AI technologies be effectively patented? And while US law has a particular statute that describes the principles for what is patent eligible, things like being novel and having practical use and being non-obvious, the Supreme Court through some landmark cases has identified certain categories of work that are judicial exceptions, meaning they are ineligible. And these include subject matters that are laws of nature, natural phenomena, or abstract ideas. And these exceptions are particularly challenging for AI because AI is based on these kind of mathematical algorithms and processes that would be considered abstract ideas in the eyes of the law. I read somewhere that IBM have even written that abstraction is a foundational characteristic of computer science. So patent offices and courts have a tough time deciding whether the kind of intangible inventions and conceptions that are related to AI-based inventions are eligible under the law. And the policy question is, do we need to reform the law? And for many, legislation appears to be the only kind of practical means to reform patent eligibility. And the reason that some people think that is because the efforts that we've seen so far in clarifying patent eligibility have had somewhat limited success. So in 2019, we saw that the USPTO adopted a framework for patent examiners on subject eligibility, and they provided this guidance on some of the kind of more murky or tougher questions. And I think their goal was really to make the process more reliable and predictable and consistent. So these guidelines include, examples of what would not be a judicial exception, what would be a judicial exception as it relates to new technologies, and when the use of mathematical algorithms, should receive a patent and not. And it did have some positive results. The former USPTO, who I've pictured here, said the guidance has helped cut rejection rates for AI from 60% to 32%. The issue comes in that the guidance doesn't actually apply everywhere. So for example, the Federal Circuit has held that it's not bound by this guidance. So in 2019, in one case, we saw them say, while we greatly respect the PTO's expertise on all matters relating to patentability, including eligibility, we are not bound by its guidance. And then in a 2020 case, they said, to the extent the office guidance contradicts or does not fully accord with our case law, it is our case law and the Supreme Court precedent it is based on that must control. So I think that's why we're seeing this push for a a reform to the kind of patent eligibility doctrine. And there are several congressmen on both sides of the aisle, including Senators Tillis, Coons, Hirono, and Cotton, that have called for a review of the existing doctrine. And I think they're hoping to see a change to some of these rules. But on the other side, there are a number of civil rights and advocacy groups that disagree. The ACLU published this coalition letter to President Biden, where they're kind of firmly disagreeing with any reform to judicial exceptions, because they believe it would allow for quote unquote more kind of bad patents to get through. And I think, especially when we're talking about AI, where there is a lot of controversy about increasing the proliferation of AI systems, especially if they're problematic, it's causing a lot of controversy. But I think in general, there first needs to be a kind of greater understanding of what impact the current laws are having on AI, and more broadly on tech innovation and the tech ecosystem, because I think the data on that is kind of missing. And especially when it comes to AI policy, and I'm sure later we'll talk about incentives. When it comes to incentives, AI policy focuses on a number of different things. How can we increase our R&D tax credits? How can we improve the regulatory environment? How can we, deal with human capital? All these different parts of how can we change immigration policy to ensure that our AI ecosystem is thriving? But you very rarely in the AI policy world, especially in DC, you're not going to hear about AI and IP. I think it's highly overlooked, and the role of IP in kind of fueling the AI ecosystem and AI innovation is largely overlooked at the policy level, I think. And it's something that should change, or I hope to see it change. And very quickly, this final point on about the global alignment on AI. The motivating question for policymakers here, I think, is that, are there inconsistencies in patent regimes around the world that make it kind of overly burdensome for individuals and companies to protect their IP in multinational markets? And I think the problem with having vastly different regimes in different countries, which, Ryan kind of described to us a little bit earlier, is that if you have largely dissimilar criteria for assessing and evaluating the different criteria, whether it be novelty or non-obviousness, whatever, it will make it harder for inventors who operate across those jurisdictions to easily protect their work across these markets. And I think if the United States wants to support global AI innovation, which is something that policymakers have top of mind, I think policymakers should ensure that they explore, coordinated approaches to IP, or like broadly coordinated approaches to IP as it relates to AI. And so I think that covers the three things I wanted to talk about. So I look forward to the discussion. Thank you.
All right, no, that's great. And so I want to pick up on what you said about incentives. And so I'm going to ask a question to the group, and anybody can chime in. Do you think that we have the right incentives to promote AI-based creativity and innovation? And if not, what should we change?
Well, as I see, I'm the only unmuted person. I guess I could pick it off, although it was pretty much the chat of my talk. I mean, as Hodan mentioned, it depends on the jurisdiction, right? And this is one of the reasons we have a globally harmonized intellectual property system, or a largely globally harmonized one, is that, intellectual property is global, and by its nature, for the most part, freely copyable and non-rivalrous. And so, it costs the same amount of money to make a new song or invent a new drug in the United States as it does in Japan. And we want, businesses to have a reasonably harmonized system for that. You don't always need intellectual property to generate content or do the sorts of things you want to do. It really is very context dependent. With patents, for example, in the software industry, there are a lot of reasons to innovate in software. It's lower cost, there's first mover advantages, there's less of a patent culture. In life sciences, the situation is really very different. It costs a lot of money after an invention to get a new drug approved. The same with creative works. It costs a lot more money to make an Avengers movie than for me to take a picture on my iPhone. But if we believe in the patent and copyright systems as the right systems to encourage the sorts of innovation and creative works that we want, then right now we don't have that system with autonomous AI generated works. And, it is not that we need to encourage an AI to do anything, but, Paul said earlier, it's not costless to do that. I agree with that. I meant you may be having no more marginal cost making these, although if you're licensing, underlying IP, it may get more complicated, but building these systems takes a tremendous amount of investment often. And so if that's something we want people doing, if we want people doing it because we like that AI is making music people want to listen to, or making AI art installations and people want that, or making life-saving drugs, then we do need to have incentives in place that, at least in the United States, we don't currently. And so wrapping that up, it would be nice if this was done through some of the test cases we're promoting. But as Hodan mentioned, it's good that Washington is turning to some of these IP issues, and hopefully this will be one that's on the domestic as well as the global agenda.
Can I quickly just respond to that? So I think that makes sense, but I just kind of want to rethink about the incentives here, right? And I think, why are people developing AI? And do we actually need to incentivize with IP protection? I'm definitely not a patent expert, but I think in the copyright context, no, I think that, the reason people are using AI to create this sort of stuff, because it is much easier than the traditional way to produce things, right? And, I agree with you, the marginal cost is much, much lower. And, I think kind of like the proof is in the pudding of where investment is. I read a fact recently that there was in 2020, and I think it's just growing since then, there was $75 billion invested in AI in companies by venture capitalists. I mean, that seems to be showing that there's some sort of incentive there. Why are they investing money in it? Are they banking on the fact that the products will be protected by IP? I don't think so. I think that they're banking on that these are creating new forms of doing things that are better than the previous way of doing things, or more efficient. And I personally, in the context of copyright, I think copyright is in my opinion to incentivize human creation, not to just incentivize the mass creation of creative work by computers.
Sure. Go ahead.
No, please.
No, please.
I was going to say a slightly tangential point, which is, rather than incentivize, I think when it comes to AI, I've seen some countries think more about democratizing AI or IP ecosystems to promote AI creations and inventions. So, I read recently that China has got, it's opening up 31 IPR centers across the country. How can we ensure that people who want to get IP protections can do it quickly, can do it easily? So I think it's a really kind of a different way of thinking about it. I don't think that I've seen anything even close in the United States policy thinking, how can we use IP and think about access to IP to encourage AI innovation.
No, great points. On the copyright front, I think there is a lot of investment in AI because a lot of benefits are expected to come from AI, kind of regardless of the IP framework. I think it matters a lot, people are investing in self-driving cars, has nothing to do with copyright, right? But if you dig into copyright, I think you see something similar to what you see with people. Not everyone is a photographer because they want to monetize their work through copyright, right? People will take photographs for whatever reason. And as we mentioned, no one's taking photographs because they're hoping they're going to get rich licensing it to an AI company to train their AI, right? But some people do make creative works and rely on the presence of intellectual property because, at least for some sorts of works, that is really something that incentivizes them. Someone writing books or studios investing in movies, there are works that require a lot of investment to make or that we otherwise think will be underproduced. It begs a very fundamental question of the copyright system. Are we doing this to reward authors or to get more socially valuable works made? And, in some sense, you don't really have to change between the two, but I think it is also a feature of the system that, IP rights are often owned by large entities, and this is a major factor in how they invest and encourage employing people to make creative sorts of work. And those large entities really often do need financial incentives. And, here you are incentivizing people to make, build, and use machines that generate socially valuable sorts of things. But I think it is at least a feature of the copyright system that people want some of the content that AI will make. And it's going to make, the world a more creative place, even with the people standing behind the machines doing things indirectly. But these are exciting times to be lawyers and debating these things.
Right? All right. So my next question is, I'm wondering, do you think that the law should be agnostic as to whether a work of authorship or an invention is created by or with the help of AI? How should the law treat it?
I can start on that one, and I think this kind of jumps off from what Professor Abbott was just talking about, in that, if it and what I had mentioned in my presentation, if you're viewing AI as a tool, it is that the law can be agnostic whether that tool was AI, or if that tool was a camera, or that tool was a paintbrush. The question really shouldn't be what tool was used. It should be, was that requisite level of human creativity involved? Can that be, used in an AI tool? For sure. So I think that, there are tools already that help with creativity. For example, in a recent version of Adobe's Photoshop, they have a way to generate clouds that are completely, AI generated. That is done at the selection of the user to improve something that already exists. And a human has to basically make those choices. I think that's a really good example of a human using an AI tool to create a creative work that certainly could be copyrightable. I think that there is that requisite level there. With having the same thing, just pressing a button and having a machine output 1 million different images of clouds, does that have the requisite level of human creativity? I don't think so, and I don't think that that output should be available for copyrighted.
I think the first step is, as we kind of discussed, to really take a step back and think about what is it we want to accomplish with copyright law. And in light of technological advances, what rules best get us to those normative goals? Thinking of AI as a tool is, I think, kind of a somewhat problematic metaphor. It is certainly a tool in that one way or the other, someone is making an AI that to a greater or lesser extent will help someone make something creative. Right. But it is not a tool in the way a paintbrush is a tool, in that, you can set it up now so that you press a button and an AI makes a piece of art. And there are people who made that AI, or people who made the AI who made the AI, right? But no one who has necessarily seen what's coming out of the AI or has an exact idea of what's going to come out. And the person asking the AI to do something may well, with some of these commercial applications, just be pushing a button, right? In which case, what the AI is doing is really what a person does that makes them an author, right? It is functionally doing that. Now, whether you want to protect something that doesn't have a direct level of human involvement, I think comes down to the question of whether or not we want to encourage the generation of that sort of output. And some of it may be cheap and some of it may be democratized. Some of these AIs may be open source and anyone can use them. And after all, the AI in our test cases is owned by a small business in the Midwest, so it isn't all just Tencent and Facebook, but some of these uses are going to require a lot of investment, as for example, movie studios, they're not deep fakes, but, use very sophisticated AI that takes a lot of training to make movie scenes that you wouldn't be safe to have people in, or that are automating actors with their permission. Some of these creative applications are going to require a lot of protection to make something that we ultimately and consumers ultimately want. And it's a little less, life-threatening when you're talking about a creative work than a life-saving drug, but still something that people think has value.
I think I would just add to this that I agree that if the work itself is novel, that the work should receive protection. But to me, it's somehow, if we understand, as we've said, that IP is an economic tool, it would seem problematic to me. We only are really talking about giving giving it the authorship or the rights, but what about punishing it, right? If it does wrong, how can we hold it accountable? How would the government be able to subject an AI system to a fair trial or fine it? You could hold. Are we going to then hold the owners and the operators of that AI system accountable if it does wrong? But if we're going to treat the AI system as a sort of separate legal person, then it would seem, and I certainly would, if I was the owner or the operator, I would plausibly say, the government shouldn't hold me responsible. You gave it the right, so it should get any sort of punishment. But if you can't punish it, then what are we going to do?
Right, that's a fair point. I mean, to be clear, in at least the version that we're promoting and what I think is being kind of discussed, at the mainstream is not giving an AI legal personality or rights. An AI can functionally author something, so it is an author, but it is not a legal person. It cannot own copyright. Whoever owns the AI owns the copyright. I think that actually protects human authors, because let's say, this Wombo application can make 10,000 really good pieces of commercially valuable art. I mean, right now I could put my name on that and sell them and be the most prolific author in history, as a means of trying to protect it. Whereas I think if you list that this is an AI generated piece of art, it maintains human authorship for people who were legitimately creative. And, right. So if I own the output of an AI, it would be much the way that I own a commercial product that makes something valuable, a 3D printer or a self-driving car. When that commercial product causes a harm, the manufacturers and suppliers of it are generally financially liable for it.
I hear that, but just to add this data point, kind of like we were saying earlier, why do people invent things? There was some really big study from the European Commission, and it looked at 10,000 inventors from 2008 to 2011 from Europe and United States and Japan, and it showed that inventors, or most employee inventors, are most intrinsically driven by the desire to solve practical problems and to be intellectually challenged and to create value for their firms. And so I guess the idea that they would be so that they would be disincentivized to create because they are being put on par with a system that's invented. I mean, how does that data point change what you're saying, or
I think the system changes like this, right? So right now you go to Siemens and you say, you go to a room of engineers and you say, look, we need a better car suspension. All of you, get testing, and you have, everyone go out to their workbench, they start designing things, and one of them says, aha, I've got a great one. Right. And now you go to a team of engineers working with a team of computer scientists, building an AI that is going to make a better car suspension. Right. Or instead of Pfizer going to a team of vaccinologists and saying, I need a new vaccine, they go to an AI that sequences vaccines, and, people interact with it to help it come up with a vaccine. At the end of the day, you have a firm that's making an investment for a patentable output that, standing on its own, is inventive. And I think the core concept we're making is it may be that a person or a machine does a better job of making that thing. Either way, the activity we want to promote is generating innovation. And you do that by being more agnostic about who the actor is and focusing on the behavior.
So, Ryan, are you saying, because I know you're trying to get patents and listing the AI, right, as the inventor, but I mean, why not just say that, the person running the AI is the inventor? Like, doesn't that solve the problem of,
Well, it solves the problem of getting a patent because a patent office won't challenge that statement. But when you litigate it and you depose an inventor and they say, well, this just came out of an AI and the patent attorney said, put my name on it, you've got some real problems. Essentially, it's that there's something that one does that makes them an inventor under US law, conceiving of an invention. But finding a problem to be solved isn't usually that, because we normally know we want a better car suspension. Training an AI to solve a problem might do it, but the people training and using the AIs are different people sometimes. And people training AIs to optimize these problems often don't even see what's coming out of the AI. So they wouldn't be inventors. Finally, someone using it might be and recognizing the value of output, but not if they are, pushing a button and saying, give me a better car suspension, and out comes, here's a better car suspension with all the data you need to file this. No one there has done the thing that makes someone an inventor. And in the absence of that, you don't have a patent, at least under current US law, right? Current US law says, if you don't have a person you can point to and say they were an inventor, you can't get a patent. And as AI gets more autonomous and more widely used, it's going to be more of a problem.
That's really fascinating. And I mean, again, disclaimer, not an expert in patent law, but I do think that this kind of goes back, or what you're talking about goes back to this idea of transparency and the importance there, and keeping records of who did what was used for what. So that way, if it is litigated, you can figure out, was there somebody that actually made the contribution that's an innovation that's protectable by picking this data set, or by excluding certain aspects from the data that was the innovation. And I think it also, when you start thinking like that, it leads to different techniques in the development process. You start thinking about, like, what am I contributing that is innovative to this process, and how can I document that?
If I could just add, I think that one thing that policymakers, or at least the National Institute of Standards and NIST, anyway, that they've been working on, which I think is really important, is we often hear these terms, right? Trustworthy AI, trustworthy data, ethical AI, bias, and we all have, just like we all have different definitions of AI, I think we all have different definitions of what these mean, and actually having very clear, measurable, definitions and standards and ways to take an AI system and actually kind of assess it for risk. And if you're a small AI developer and you want to do something trustworthy, that you have a very clear definition of what you need to do in order to pass these, universal benchmarks. I think that's what we really need to be moving more towards, is this kind of standardization and understanding of what we all mean.
All right, I'm looking at the clock and we have 5 minutes left. I don't even know where the time went. I feel like we're just scratching the surface here. And I have a list of questions and I haven't even got through like a third of them. And so with the time that we have left, though, I do want to talk about, how can we make sure that AI is employed in ways that respect the IP rights of others. And so we talked earlier about facial recognition, AI looking at 10 billion images. Well, I'm imagining that that's the 10 billion copies were made along the way. And so, is that fair use? Is that the answer? And And I don't know if we have a similar thing. I always hear about this in the copyright context. Maybe there's a similar issue in patent law that Ryan could tell us about. But what do we need to do to make sure that IP is respected as we advance with AI?
Well, I guess I'm unmuted, so I'll start talking. I think it starts with us, thinking carefully about the impact of these technologies and deciding what it is the law should be doing and what rules will get us there. So, one of the big issues in AI and IP is, should there be exemptions to copyright, or should it be considered fair use for text and data mining and training in AI? Right. And if you think that, that's the right answer, then what Clearview is doing under IP law would be fine. And if you think that that isn't the right answer and that is something that content creators should be remunerated for, then you shouldn't have an exemption like that. Right. But it does come back to sort of a public discussion of, what do we want out of the law? What is fair and reasonable, and how will we promote, personal privacy, compensating creators, developing AI? At that point, it's a combination of having these discussions and getting regulators involved in it. And for individual actors, having good governance systems in place and making sure, if you're running AI systems, that you have, teams of people involved in this who aren't just software programmers, but lawyers and ethicists, understanding how to make a framework and how to have board oversight, so that you don't find out, what, my AI was trained on 10 billion random pictures from the internet, and I'm now facing a wave of litigation in, a bunch of jurisdictions.
I can make the same sort of caveat that Paul makes. I'm certainly not an IP scholar, but thinking about how it can respect the IP rights of others. If you're thinking about AI, it feels like it's the broader question of how can we ensure that any AI system is doing what we want it to be doing. And I think that really speaks to the idea of creating a framework for general algorithmic accountability. How do I know that the system is working in the way that the operator wants it to? Are we ensuring that operators employ a number of different mechanisms like transparency and explainability, confidence measures, and procedural regularity? If there are kind of harms, are we able to identify and rectify them? Do we have impact assessments? Do we have error analysis? So I think it kind of speaks to this broader question that we are having about AI systems in general.
And can I just pick up on what Dr. Abbott was talking about with fair use and the text and data mining exceptions? I think that there's clearly a lot of confusion and gray area in the law. There have been zero fair use cases on this in the U.S. I think for a company like Clearview AI to take the position that there's no IP risk is not a very good idea. And I think any serious and responsible developer is going to think about where they get their data and not take such a position. And when a fair use analysis comes up, it's going to take into account all of the factors. And as I mentioned in my presentation, you have to look at the output, right? Is what's being output from that AI system competing directly with the data it was trained on? If so, I don't think that's fair use. And there are definitely solutions. Plug for Getty Images, we can license data, and we do for a lot of big companies and small companies at reasonable prices. But we're not the only ones. It is possible to get data without with having legal certainty that data is not going to cause problems. If you want to take the risks like Clearview does, you're probably going to be subject to a lot of litigation. We'll see where that ends up. It's going to be really interesting as these cases go through, because they're going to happen, and we'll just have to see where it ends up.
This is all super fascinating, and I'm sorry to say that our time is up, but I have a feeling that, over the next few years, we're just going to be hearing more and more about the intersection of AI and IP. And I'm very curious to see where things go, in the US and abroad. It's a fascinating topic, and I really appreciate all three of you for taking time out of your day to be here with us. And with that, I'm going to say thanks to Paul, Ryan, and Hodan, and thanks to all the viewers for joining us today. So long. Thanks, everybody.